Welcome back to the Making International Law in Korea video series. In this video, I'm going to explaining the overview of the program or the Making International Law in Korea. The development of international in Korea is traced back to the late 19th century when Korea was confronted with public international law introduced by the Western imperial state and further influenced by the Japanese colonization from 1910 to 1945, and the U.S. military administration in the southern half of the Korea from 1945 to 1948. The Republic of Korea was formally established in 1948 with the adoption of its first constitution. The history and legacy of Korea play an important role in shaping the contours of Korea's legal system as well as Korea's international relations. The legal system of Korea particularly underwent drastic changes during Japanese colonial rule as the Japanese government tried to apply their civil law system based on the continental European legal system to Korea. Such legal changes imposed under colonial rule created challenges because Korea was faced with a conflict between its deep-rooted Confucian traditions and the newly incorporated European-oriented legal principles. After Korea gained its independence in 1948, the issue of reconciling Confucianism and colonialism in Korean law was additionally intertwined with the principles of constitutionalism that came about due to the growing influence of the Anglo-American legal system in Korea. Korea's approach to international law is explained through the interpretation of its constitution, which stipulates in relevant parts that the treaties duly concluded and promulgated under the Constitution and the generally recognized rules of international law shall have the same effect as the domestic law of the Republic of Korea. In accordance with this provision, international law has been generally accepted as Korean domestic law and incorporated into Korean domestic legal system. While the Constitution explicitly set forth that the treaties duly concluded are accorded with the same status as the domestic law of Korea, there is no specific mention of the customary international law. The term generally recognized the rules of international law is largely interpreted to mean customary international law. Regarding the status of international law in Korea's domestic legal system, the prevailing view is that both treaties and customary international law stand equal with domestic regulations. While the treaties ratified with the consent of the National Assembly are deemed to have a status equal to statute passed by the National Assembly, those simplified treaties without legislative consent are deemed to enjoy the same status as decrees issued by the President and various ministries and enforcement decrees under the statute. The tumultuous experience of the Korean nation in the 20th century within the context of the international relations in Northeast Asia has a very significant impact on Korea's attitude toward and practice of public international law. Korea has many issues to be settled under international law. Such issues include, but not limited to, territorial dispute with neighboring countries, issues of the transitional justice, and issues regarding the limitation of maritime boundaries and fisheries. As to adjudication as a means of this settlement, Korea has not recognized the compulsory jurisdiction of the International Court of Justice. However, Korea has accepted the compulsory jurisdiction of the ICJ For disputes arising out of the interpretation or application of the optional protocol to the Vienna Convention on Diplomatic Relations concerning the compulsory settlement of the dispute, as well as the optional protocol to the Vienna Convention on Consular Relations concerning the compulsory settlement of disputes. Korea, as party to the UN Convention on the Law of the Sea, has submitted a declaration under UNCLOS Article 298 in 2006. Korea generally remained inactive in employing the internal adjudication as a means of dispute settlement. Moreover, Korea has not employed non-judicial means of dispute settlement such as inquiry, mediation, or conciliation. The only bilateral agreement concluded for the very purpose of this settlement is the exchange of notes concerning the settlement of dispute concluded between Korea and Japan in 1965. One of the possible explanations for Korea's rather confined choice for dispute settlement is that most issues at stake are delicately related to territorial matters, which can never be easily left for third-party decision. As a full-fledged member of the international community, Korea has been actively involved in a number of activities at international organizations and conferences. Korea particularly devoted to multilateral diplomacy at the United Nations and gradually pursued bilateral diplomacy even in the multilateral forums such as the G20 summit. Moreover, Korea utilized its UN diplomacy to extend the scope of its global participation in major global agendas, including but not limited to human rights, environment, terrorism, and poverty. The hosting of major international forums such as the G20 Seoul Summit, the 2012 the Nuclear Security Summit, and the High-Level Forum on Aid and Effectiveness in 2011 showed Korea's national capacity to serve not only as a global agenda setter, but more importantly, as a bridge builder between developed and developed countries. Korea's engagement with the international community extends to humanitarian and disaster relief efforts through its participation in the UN peacekeeping missions. Korea's experience in international relations is rather unique in a sense that Korea emerged not only from Japanese colonialism, but also from a war-torn country to become an Asian power. Some significant international legal issues, including those which resulted from the Japanese occupation of Korea, as well as from the Korean War, as highlighted as follows. The first, let me touch upon the legacy of colonialism. The historical fact that Korea ruled and controlled Korea from 1910 to 1945 caused many international law issues, some of which have still not been settled between Korea and Japan. The most critical and fundamental question, among others, is whether the Japanese ruling of Korea was based on the ground of international law. In particular, the validity of two treaties, the Treaty of 1905, which deprived Korea of its diplomatic sovereignty, and the Annexation Treaty 1910, have been the subject of much controversy. Upon Korea's signing the Treaty on Basic Relations with Japan in 1965 to normalize diplomatic relations, the two countries tried to solve unsettled legal issues by concluding additional treaties, such as the agreements on the settlement of problems concerning property and claims, agreement concerning cultural asset and cultural cooperation, and agreement concerning legal status and treatment of the Korean residents in Japan. Without any success, the issue on legality or legitimacy of Japan's ruling over Korea under international law was never solved and rather ended up with vague provisions in the treaty, which in turn raised a matter of interpretation until the present time. Another key issue arising out of Japan's colonization of Korea is related to Dokdo, a group of small islands in the East Sea, because the issue surrounding Dokdo is often raised in the context of the Japanese imperialism and expansionism into Korea. And then let's talk about international legal issues arising from the Korean War and inter-Korean relations. Armed conflicts occurred in Korean Peninsula in the early 1950s, has raised a number of important legal issues on the international law. The Korean War posed many legal issues, especially related to international humanitarian law, such as the legal characteristic of armed conflicts, the applicability of rules of engagement, and legal meaning of a long-standing ceasefire. As North Korea launched an arms attack against South Korea on June 25, 1950, a series of resolutions were adopted by the UN Security Council, and it was the first time the UN Security Council had authorized the use of force since its inception in 1945, and members of the United Nations acted collectively to repel the aggression. As a veto by then Soviet Union was frequently used to block the numerous Security Council initiatives during the Korean War, the UN General Assembly adopted a resolution known as Uniting for Peace, which states that if the Security Council fails to exercise its primary responsibility to act as required to maintain international peace and security, due to the lack of unanimity of the permanent members, the General Assembly should take over to keep impetus for peace. While a military demarcation line was drawn on land at the time, the Inter-Korean Armistice Agreements were signed on May 27, 1953. Such a demarcation line did not extend into the maritime areas. The seaward extension, known as the Northern Limit Line, so-called NLL, which was drawn by the UN Command General Mark Clark in 1953, has remained contentious and caused confrontations between two Koreas, as the NLL was not officially part of the Armistice Agreement. Some key inter-Korea issues, among others, include the statehood and recognition, as well as the legal consequences of the agreement signed by the two Koreas. An issue arises from the provision of the Constitution of the Korea, which stipulates that the territory of Korea shall consist of the whole Korean peninsula, while two Koreas were respectively admitted to the United Nations at the same time. The UN membership issue raised a legal question as to whether Republic Korea recognized North Korea as a state. The issue gets more complicated as a question also arises as to the legal characteristic of the agreements on reconciliation, non-aggression, and exchange and cooperation between South and North, signed in 1991, which recognized that relations between two Koreas is not a relationship as between states, but rather a special one constituted the temporary in a process of the unification. Let me move to touch upon the issues of the sea. The situation at the center of the Northeast Asian seas, the waters that surround the three sides of Korea, are important for economic, military, and strategic concerns. Such concerns embrace a wide range of maritime issues, including maritime delimitation and competition for marine resources. Korea has emerged in important legal matters pertaining to the law of the sea that are of vital importance, especially in relation to maritime delimitation in the zones established by the UN Convention on the Law of the Sea. There remains the issue of maritime delimitation due to the overlapping claims of the continental shelf, with the neighboring countries such as between Korea-China in the West Sea and between Korea-Japan in the East Sea. The contribution on the part of Korea in relation to maritime issues, including its active engagements in international efforts to protect marine safety and marine environment. Since Korea joined the Convention on the International Maritime Organization, Korea as a member, a category council with the largest interest in providing international shipping services, has been leading the development of the maritime technology, such as e-navigation, eco-friendly vessels, and autonomous vessel technology. Let me touch upon the democracy and international human rights law. The development of human rights in Korea is closely related to the development of democracy in Korea, achieved through the mass protests against the dictatorship and military regime from the 1960s to the 1980s. With the development of democracy in Korea since early 1990s, the Korea began to accept major international human rights treaties, ratifying the International Covenant on Civil Political Rights and its protocol in 1990 and the International Covenant on Economic, Social, Cultural Rights in 1990s. Since then, Korea became the party to major international human rights treaties, such as the Convention on the Rights of the Child and Convention Against Torture and other cruel, inhumane, degrading treatment and punishment, and optional protocol to the Convention on the Rights of Child on the involvement of children in the armed conflict, and the Convention of Rights to Persons with Disabilities. In 2001, National Human Rights Commission was established as a National Human Rights Advocacy Institution, along with several Truth and Reconciliation Commissions to investigate human rights violations under previous authoritarian regimes. One of the recent human rights issues include the right to consensus objections to military service. Consensus objection has been a topic of much debate in Korea for decades, especially in cases involving Jehovah's Witnesses. The Supreme Court and Constitutional Court have consistently affirmed the punishment and consensus objector under the Korean Military Service Act. However, in 2018, the Constitutional Court held that the Korean law did not recognize consensus objection was not consistent with the Constitution. In the same year, the Supreme Court ruled that consensus objector was justifiable under the Military Service Act. The Korea was colonized in the early 20th century, achieved its independence, and rose from the ashes of the Korean War to become an Asian power. Korea remarkably emerged from the Japanese colonialism and subsequently became a divided nation occupied by the communist forces in the north and the United States in the south. This division culminated in the Korean War from the 1950 to 1953, which ravaged the peninsula and left Korea as one of the poorest countries in the world. Korea is now ranked in the 10th or 11th largest economy in terms of the GNP of the world. Korea's modern history parallels the tumultuous events of the Northeast Asia, when the long-standing genocentric order was apparent through the Western colonialism and Japanese aggression, leading to World War II. For Korea, the post-World War II era was marked largely by the Cold War, and after the fall of the Soviet Union, it has been in the midst of the reconfiguration. The balance of power in the region can be ascribed to the economic prowess of both China and Japan, and the nuclear ambitions of North Korea, and the U.S. national interests. As the post-Cold War era in Northeast Asia continued to be influenced by the power politics, it has also seen an increased need for international law due to the forces of the globalization, regional concern over ocean resources, and trade and other non-security matters.